At the conclusion of this lecture, you will understand how a contract can be discharged, understand how a contract can be breached, be able to understand how damages can be awarded under contract law, and be aware of the numerous equitable remedies available for contract breaches. The general rule is that the parties must perform precisely all the terms of the contract in order to discharge their obligations. A contract may be entire or divisible. With a divisible contract, part of the consideration of one party is set off against part of the performance of another. Where the party to whom the promise of performance was made receives the benefit of partial performance of the promise, under such circumstances that he is able to accept or reject the work, and he accepts the work, then the promisee is obliged to pay a reasonable price for the benefit received. Where a party to an entire contract is prevented by the promisee from performing all his obligations, then he can recover a reasonable price for what he has in fact done based on the contract's existing terms. When a person fully performs the contract, but subject to such minor defects that he can be said to have substantially performed his promise in certain circumstances. Tender of performance is equivalent to performance in the situation where Party A cannot complete performance without the assistance of Party B, and Party A makes an offer to perform which Party B refuses. At common law, in the absence of contrary intention, time was regarded as being of the essence. Thus, if a party did not perform on time, he could not enforce the contract against the other party. Certain statutes can remove the requirement of time of the essence. The equitable principle is that there is no time of essence in contracts. However, there are 3 exceptions to this. The contract expressly states that time is of the essence. Time was made of the essence by the giving of notice, during the currency of the contract, to perform within a reasonable time, where from the nature of the surrounding circumstances or from the subject matter of the contract, it is clear that time is of the essence. The general rule is that what has been created by agreement may be extinguished by agreement. A breach of contract is committed when a party without lawful excuse fails or refuses to perform what is due from him under the contract, and/or performs defectively. Failure or refusal to perform a contractual promise when performance has fallen due is prima facie. Defective performance is where a person promises to do one thing but does another, which differs, for example, in time, quantity, or quality. This amounts to a breach. The effect of such a breach often differs from those of a complete failure or refusal to perform. Incapacitating oneself, for example, a seller commits a breach of contract for the sale of a specific thing if he sells it to a third party. This refers to a contract which comes to an end in accordance with its terms, either because it has a fixed expiry date, or because there is a right to terminate contained in the contract. An anticipatory breach occurs when, before performance is due, a party either rejects the contract or disables himself from performing it. Repudiation is a clear and absolute refusal to perform, which includes conduct showing that the party is unwilling, even though he may be able to perform. Disablement. This occurs, for example, where a party disposes elsewhere of the specific thing which forms the subject matter of the contract. Where one party commits an anticipatory breach, the other can elect to A. Keep the contract alive by continuing to press for performance, in which case the anticipatory breach will have the same effect as an actual breach, or B. Accept the breach, in which case he has a right to damages and termination. Termination is the remedy by which one party, the injured party, is released from his obligation to perform because of the other party's non-performance. Breach gives the injured party the right to terminate the contract, and this can only be brought by the injured party. The injured party, in order to bring a termination, must provide a notice to this effect to the other party in breach. Once termination has taken place, the injured party is no longer bound to accept or pay further performance. However, termination does not release the injured party from his duty to perform obligations which accrued before termination. At law, the right to terminate for breach arises in 3 situations. A. Repudiation, where a party evinces a clear and absolute refusal to perform. B. Impossibility, where a party disables himself from performing. C. Substantial failure to perform. Any defect in performance must attain a certain minimum degree of seriousness to entitle the injured party to terminate. A failure in performance is substantial when it deprives the party of what he bargained for, or when it goes to the root of the contract. For less serious breaches, a right to damages may arise, but not a right to terminate. Under the doctrine of frustration, a contract may be discharged if, after its formation, an unforeseen event occurs which makes performance of the contract impossible, illegal, or essentially different from what was contemplated. A good case on point here is Avery v. Bowden. The position at common law is that frustration discharges the parties only from duties of future performance. Rights accrued before the frustrating event therefore remain enforceable, but those which have not yet accrued do not arise. A misrepresentation is a false statement of fact made by one party to another, which, whilst not a term of the contract, induces the other party to enter into the contract. An actual misrepresentation must be a false statement of fact, not an opinion or future intention or law. Silence does not normally amount to misrepresentation. However, the representer must not misleadingly tell only part of the truth. Thus, a statement that does not present the whole truth may be a misrepresentation. Where a statement was true when it was made, but due to a change of circumstances becomes false, there is a duty to disclose the change. A misrepresentation may be A. Fraudulent, made knowingly, without belief in its truth, or recklessly. B. Negligent, made by a person who had no reasonable grounds to believe that it was true. Or C. Innocent, made in the wholly innocent belief that it was true. There are multiple remedies available once misrepresentation has been proved. A. Rescission. This sets aside the contract and aims to put the parties back in their original position, as if the contract had never been made. Rescission can be sought for all cases of misrepresentation. However, this is a discretionary remedy, meaning that the courts will not always allow a party to rescind, and the injured party may lose the right to rescind if he has already affirmed the contract. He does not act to rescind in a reasonable time. It is or becomes impossible to return the parties back to their original position, or a third party has acquired legal rights as a result of the original contract. B. Indemnity. The court may order payment for expenses necessarily incurred in complying with the terms of the contract. C. Damages. This remedy varies according to the type of misrepresentation. In fraudulent misrepresentation cases, there is an automatic right to damages. In negligent cases, the injured party may claim damages under common law or under the Misrepresentation Act of 1967. In situations of innocent misrepresentation, the court has discretion whether to award damages and may opt to award damages in lieu of rescission. A contract may be void or voidable if a mistake has occurred. If a contract is void, then it is so ab initio, meaning from the beginning, as if the contract was never made. In such cases, no obligations will arise under it. Alternatively, if the contract is voidable, the contract will have been valid from the start, and obligations may arise under it despite the mistake. A mistake can be classified into 4 different terms. Common mistake. A common mistake is one where both parties make the same error relating to a fundamental fact. This makes the contract void. Unilateral mistake. This occurs when only one party is mistaken. This makes the contract void. Mutual mistake. A mutual mistake is one where both parties fail to understand each other. Essentially different. This is only acceptable in extreme circumstances. Damages are the common law remedy for breach of contract and are available as a right where a financial loss has been sustained by the innocent party. The injured party must show that a. Actual loss has been caused by the breach. b. The type of loss is recognized as giving an entitlement to compensation. And c. The loss is not too remote. In deciding what damages are to be paid, the courts deploy two rules to determine their decision. The first relates to the rules relating to remoteness of damage, and the second relates to the rules regarding the measure of damages. Not every type of damage caused to the plaintiff will be recoverable for breach of contract. For a damage to be recoverable, it should not be too remote, and it must have been in contemplation of both parties. The essential means that the party in breach can only be held liable for abnormal consequences where they have actual knowledge that the abnormal consequences might follow. Thus, in Victoria Laundry Limited versus Newham Industries Limited, the plaintiff was able to claim for damages with respect to the normal profits, but could not claim abnormal profits, which would have resulted from an especially lucrative contract, which the defendant knew nothing about. The rule in Hadley versus Baxendale states that damages will only be awarded in respect of losses which arise naturally, i.e., in the natural course of things. The general rule is that damages in contract are intended to be compensatory rather than punitive. The aim is to put the injured party in the same position they would have been in had the contract been properly performed. The level of damage cannot be greater than the damage suffered by the injured party. The expectation loss is compensated except where this permits the innocent party to escape responsibility for any loss they would have made in the contract in the absence of breach. See the case of CCC Films London Limited versus Imperial Quadrant Films Limited 1985 for a practical example. Where the breach relates to a contract for the sale of goods, damages are usually assessed in line with the market rule. The injured party is under a duty to take all reasonable steps to mitigate their loss. It is possible, and common in business contracts, for the parties to agree to make provisions for possible breach by stating in advance the amount of damages that will have to be paid in the event of any breach occurring. Damages under such a provision are known as liquidated damages. Where damages are deemed inadequate, the court may take an order for specific performance, which will compel the party in breach to fulfill the terms of the contract. The court will only grant specific performance if, under all circumstances, it is just and equitable to do so. Specific performance may be refused if the injured party has acted unjustly or unfairly on the basis that the injured party must come to equity with clean hands. Quantum meruit means that a party should be awarded as much as he had earned. If the parties enter into a contractual agreement without determining the reward that is to be provided for performance, then, in the event of any dispute, the court will award a reasonable sum. A court may restrain a party from committing a breach of contract by injunction. Interlocutory injunctions are designed to regulate the position of the parties pending a full hearing of a dispute or permanent. Prohibitory injunction orders a defendant not to do something in breach of contract, whereas a mandatory injunction requires a defendant to reverse the effects of an existing breach. In conclusion, there is a difference between discharging a contract and breaching a contract. The type of breach will raise certain remedies. The remedies for contract breaches are both equitable in nature and can result in damages.